Members, it's already the scheduled time and we formed a quorum. May I call the meeting to order? Please invite the administration to join us now.
聽緊。好，歡迎政府。
Welcome, representatives from the administration. Please refer to the attendance list already tabled. On the 17th of February 2015, that is our last meeting, the administration indicated that having considered views expressed by members at the committee, it will consider setting the procedures for license renewal. And in the paper submitted by the administration for this meeting, IECE CB2-1094/1415-02, sets out the preliminary thinking of the administration on procedures for license renewal. Please refer to para 3 through 5. And then at the last meeting, members scrutinized clauses 11 to 17 of the bill, and a number of issues were raised. Members may refer to paper CB 903, rather 1094/01 for details. And the administration has provided a response to these concerns in paper bracket 02, and members may refer to para 16 or 10 to 16 for responses. And the paper has also set out the procedures, average waiting time, and average legal costs for processing building management cases in the Lands Tribunal. For details, please refer to para 11 to para 21. Mr. Jack Chen, Director of Home Affairs, would you like to supplement to the paper submitted by the administration? Thank you, Chairman, and good morning, members of the Council of the Bills Committee. At the two meetings dated the 9th and the 27th of February, we have already prepared a written response to the concerns. And I'd like to add a few points to the paper. Regarding procedures for license renewal, we have considered the variable comments made by members on the procedures. We also reported our preliminary thinking to members at the last meeting, and for details, please refer to paras 2 and 3. Subject to members' view, we are going to propose corresponding CSAs to the bill. And the second point is the waiting time and legal costs for processing building management cases in the Lands Tribunal. Members asked about the procedures, average waiting time, and average legal costs for building management cases in the Lands Tribunal. We've invited the judiciary to provide the following information. According to the judiciary, the procedure is divided into 3 stages. First, filing of a case. Second, setting down to trial. And third, the proper trial. For details, please refer to paras 11 to 20. According to information by the judiciary, the average time required in stage 1 in 2014 was 108 days. Depending on the complexity of the case and the state of preparedness of parties concerning preparing the witness statements and or expert reports, the number of applications or respondents involved in the proceedings, and the time taken for mediation. Regarding Stage 2, in 2014, the average waiting time was 30 days. In other words, in 2014, from filing of a case to the actual trial, the average time required was 138 days of about 4.5 months. Of course, in case of an emergency, the OC or the landlord or relevant parties may apply for an injunction from the court. And the average legal costs borne by landlords in building management cases, well, the judiciary has not kept any such statistics. Earlier this month, the HAD, together with two authoritative arbitration organizations, that is the Hong Kong Arbitration Association and the Hong Kong Mediation Society, have started a 2-year free mediation service. The two organizations have sent 155 professionally recognized mediators to provide free of charge service to OZs and property owners and building management companies to resolve disputes, hoping that it can help to settle cases peacefully without having to go to court. All right, any follow-up questions, please? If there are no follow-up questions, we'll continue with our clause-by-clause scrutiny of the bill. We can start from Clause 18, Part 5, Authorities' power to conduct investigation, i.e. page C2772 and C2773. Director, can you please explain the provisions to us? As I will defer to Mr. Franco Kwok, and we'll be happy to take questions. Thank you. Part 5, Clause 18 of the bill is about the authority's power to conduct investigation. Under subsection 1, the authority may conduct an investigation into any conduct of a licensee if A, the authority has reasonable cause to suspect that the licensee has committed a disciplinary offense, or the licensee no longer meets any of the prescribed criteria for holding the license, or if B, the authority has received a complaint against the licensee alleging a matter mentioned in para A 1 or 2. Subsection 2. The authority is not required to conduct an investigation to deal with a complaint if it is satisfied that a complaint is misconceived or lacking in substance. Subsection 3. If the authority decides not to conduct an investigation to deal with a complaint, it must, as soon as practicable after it makes the decision by notice in writing, given to the complainant, notify the complainant of the decision and give reasons for the decision. Subsection 4. The authority must, as soon as practicable after it decides to conduct investigation into conduct of a licensee, notify the licensee in writing of the substance of the matter being investigated. Do we have any views or follow-up questions on this section? Mr. Wong Kwok Heng, Chairman. Now, the clause talks about a complainant. What if it is a company? What if the authority should investigate a company or an organization. According to under the bill, a complainant includes the licensee, and a licensee can be a company. Any follow-up? No, thank you. Legal advisor. Thank you. With regard to Clause 18.2, the authority may decide not to conduct an investigation if it is satisfied that a complaint is misconceived or lacking substance. Or are there other circumstances under which the authority can decide not to conduct an investigation? For instance, the case has been investigated and has come to a conclusion, or if the complaint is frivolous and malicious, not a genuine complaint. We do agree that if a complaint is frivolous and trivial, then the authority should not waste time and resources to conduct an investigation. However, the phrase lacking in substance can cover frivolous and trivial complaints. Legal advisor. What if the case has been brought to the authority already, and after investigation, the authority has decided that no investigation is needed? Then, if the case has been investigated before, then there is no need for the authority to deal with the complaint unless there is new evidence or new development. Okay?
Mr. Wong Kok-hing, I'd like to ask whether it has been considered implementing measures to prevent abuse, for example, to use the authority to investigate for example, if there was a smear campaign launched and the authority was being used to investigate the target. That is an important consideration. In the consultation committee, we had discussed that we feel that the authority should focus on real cases. If there are smear campaigns or frivolous cases, then the authority can reject such complaints. I'd like to follow up if the complaint included slander or it had malicious intent to smear the target's reputation. Are these actions accountable? These unreasonable, unlawful complaints, can they be accountable? If not, then I'm afraid the mechanism might be subject to abuse. Yes, Chairman. According to our bill, we have suggested that if any person who intentionally provides false information to the authority to mislead the authority, then according to Clause 22 of our bill, the authority can prosecute and there is a criminal liability. Thank you for the response. I'd also like it to have the response on record. I'd like to follow up with whether we have regulations where after receiving a complaint, does the authority have a performance pledge? How long do they need to, how much time do they have to respond, to investigate or not investigate? Is there a performance pledge? Yes, Chairman. In the consultation committee, we had suggested that when the authority receives a complaint, first they need to confirm the receipt of such complaint and when they start investigations. Yes, in the guidelines we will include a performance pledge. We will have a number of days, we'll have a number where they need to handle the case or respond to a complaint within a certain number of days. Next, Yip Kok Kim. The complaint, if it's anonymous, will it be accepted? Because in Clause 18.4, after receiving a complaint, they need to respond. What if it's anonymous? How can you respond to an anonymous complaint? And similar to Mr. Wong Kok Hing's question, in bracket 4, you mentioned as soon as practicable. I think you're referring to time. It's like the performance pledge mentioned just now. So the phrase "as soon as practicable," is that common in the bills? Shouldn't you say within a month or two? Wouldn't that be more clear than "as soon as practicable"? The second question regarding as soon as practicable, our law draftsman could respond, but our purpose is to indicate that the authority will act as soon as possible. And what do we mean? Well, in our future guidelines, code of practice, we will define that. Mr. Yip referred to an anonymous case scenario. He is correct. In our bill, our suggestion is that we will only handle written complaints with a signature, because a complaint is a serious incident. It has serious consequences. We will only accept signed complaints. Our understanding is that other mechanisms will only accept signed complaints. Mr. Lam, in bracket 4, it says the authority must, as soon as practicable, conduct an investigation. That is important because each case would be different, and when they conduct investigation, they might take a lot of time, and then the decision they might need to gather information from the complainant. They might spend a lot of time in this part of the investigation, but they should act as soon as practicable. There might be delays, they might need more time, but that would depend on a case-by-case basis. Well, I agree with not handling anonymous complaints because there is a penalty in Clause 22 for false complaints and so on. So you should not handle anonymous complaints. But regarding as soon as practicable, my question is, in other main legislation, is that common? Yes. But now you want to implement this in a code of practice. But you should have a time frame in mind, whether it's 3 months or half a year. You need to be clear. We're talking about actions after investigation. Investigations into the conduct of a licensee. So, since you are considering a performance pledge, shouldn't you make it clear? My suggestion is that couldn't you come up with a more specific time description? So whether it's the authority or the complainant, they can have a better indication of the time that is involved. Yes, we are aware and understand members' concern. In drafting the law, we typically describe these have to be dealt with as soon as practicable. In the code of practice, we will give a specific time frame. That's our suggestion. Now, regarding the actual days, then this is up to the authority. They would have to make reference to staff available and experience to come up with a figure. But we will monitor the authority and make sure they respond as soon as practicable. Okay, legal advisor. Regarding the authority handling anonymous complaints, it's not spelt out in the bill, so we have to interpret it indirectly. So, under the Privacy Personal Information Ordinance, we have similar drafting. Under the Personal Privacy Information, the authority can refuse or seize an investigation, and in B and C, that's what they say. If the complaint is lodged anonymously, or if the complainant cannot be identified or found, so the authority, in the future, they can deny anonymous complaints. That's a very good suggestion. Our original intention was that in Clause 18 and Clause 19, the authority will have to set down some guidelines. The mode of how a complaint be lodged. They need to include an address, a communication address, such that the authority can correspond with the complainant. Well, whether that is sufficient or whether, as the legal advisor had suggested, we will go back and reconsider to see what is more effective. Any more questions regarding Clause 18? I don't insist on my suggestion regarding a specific time frame, but I think it would enhance transparency and it would assist in compliance. Yes, we're willing to reconsider. If we don't have further questions, we'll continue. Mr. Koch. Clause 19 refers to guidelines. For the purposes of Section 18(1)(b), the authority may issue guidelines indicating the manner and form in which a complaint is to be lodged and the particulars that the complaint must contain. And second, in bracket 2, the authority may amend the guidelines. These guidelines and amendments may be published in any manner the authority considers appropriate, and in bracket 4, the guidelines and nor the amendments made to them are subsidiary legislation. Thank you, Chairman. Wong Kok Heng. Thank you, Chairman. I'd like to ask, the guidelines in bracket 4, if it's not a subsidiary legislation, is it legally binding? If the guidelines are not complied with, what are the consequences? Could you elaborate? Thank you, Chairman. According to Clause 19, bracket 1, for the purposes of Section 18(1)(b), guidelines may be issued. So if the complainant does not submit a complaint in the manner and form that is acceptable by the authority, then the authority can deny these complaints because it might lack substantial information or it's not sufficient for conducting an investigation. my question was not answered. So if we don't comply with your format, the law is not breached. They can write up anything they want. Well, the authority is given the power to issue guidelines to facilitate a complaint being lodged. We're not trying to make any action a breach of the law. We just want to facilitate the work of the authority. Well, I'm concerned that drafted in this manner, then so when people lodge a complaint, it might not be a bona fide. So could you tighten up the drafting? That is, the complaint format has to be a strict and formal complaint. It has to rely on facts. They cannot lodge a false accusation. So could you consider that? I fully understand Mr. Wong's concern. In clause 19, bracket 4, it just describes a fact that our guideline, or our suggestions, our guidelines, their publication are not made in the manner of a subsidiary legislation. It doesn't mean that they're not legally binding. It's just that it's not being drafted in the manner of a subsidiary legislation. So any person submitting a complaint or providing information, if they know it's false and misleading, then according to other clauses in our bill, that person can be prosecuted. There is a criminal liability. Just having 19.4 doesn't mean they can launch any arbitrary complaint and provide any information to the authority. I welcome such a clear response. I'd just like to have it on the record. The response was very clear. I'm also engaged and participate in property management for many years. I feel that when we draft the law, we need to be neutral, and we also need to foresee the likely scenarios that might occur, because different interests are competing, and some people might want to abuse these laws and lodge complaints. So it has to be strict.
So I am satisfied with the director's reply. All right, does any other member have other questions in relation to clause 19? If not, Mr. Clark, please go on. Clause 20 is an appointment of investigators. The authority may in writing appoint any of its employees or any other person as an investigator. We still got him. Yes, appointment of his employee, it is appropriate. But what do you mean by any other person? What are they? What do you have in mind? Thank you. We have discussed in detail the complaints, and the complaints may cover a wide range of issues, and therefore the authority may appoint people other than its employees. Its employees are, of course, knowledgeable in these matters, but when the complaint is about particular engineering work, then employees or engineers may be required. And if it is about very complicated financial matters, then accountants may have to be appointed to provide assistance. And therefore, we empower the authority in this bill to appoint other persons as investigators. Otherwise, the authority will not have the power to appoint professionals outside its organization to investigate. I think similar provisions are found in other pieces of legislation. But you have to pay professionals, right? You cannot ask them to serve on a pro bono basis. You may be employing surveyors or accountants, so is it by means of appointment or to employ professionals to assist its employees to investigate when necessary? Shouldn't you do it this way? Because any other person here sounds rather uncertain. Yes, Mr. Ip is correct. Yes, employment of special investigator is one way, but sometimes we may need overseas experts to advise on a particular complaint. There may be no employment relationship. If we say to appoint any of his employees or to employ any other person, there may be overseas experts serving or advising on a pro bono basis, and that will not be able to. If we draft the bill in that way, we may not be able to cover that scenario. So it may be more appropriate to say to appoint any of his employees or any other person. Mr. Ip Kok Him. Mr. Wong Kok Heng. How can you avoid conflict of interest in the bill? Because some complaints may involve an enterprise or a big group, and how can the authority avoid conflict of interest in appointing investigators? The authority will have a very strict declaration of interest system. Anyone who's involved in the work of the authority should be subject to the regulation of the system for declaration of interest. If there is any conflict of interest, then the person concerned should not continue to deal with the case. Where can we see the relevant clauses on avoidance of conflict of interest? Usually, it will be specified in the Code of Practice, a conflict of interest and declaration system. The authority will have its Code of Practice to regulate its staff and members on declaration of interest. I hope the Secretariat can put on record, because I've asked a number of questions, and the reply I get, as always, in the Code of Practice. So can the Secretariat please jot it down, because I may not be able to remember so many things. Mr. Chen, can you tell us when it comes to the appointment of investigators, if it is persons other than employees, will the appointment be done by the chairman of the authority or the director? And we're concerned as to the number of investigators required. They will have certain powers. And if there is conflict of interest, how will it be handled? Director, you told us that there will be clear guidelines in the future code of practice for the authority. Can you tell us your framework now? Thank you. Under the bill, the authority is subject to the scrutiny of the ICAC and Ombudsman. So its operation will be subject to the regulation of these two bodies. Therefore, the authority must devise a very detailed and strict code of practice to avoid conflict of interest. I'm very confident in the authority, and it is also specified under the bill that it will be subject to the regulation of these two bodies. So we're quite confident that the authority will be able to operate to avoid conflict of interest and transfer of benefits. Yes, I know that the authority is subject to the regulation of the two bodies. That's the overall picture, but we are talking about the appointment of investigators. Well, there is nothing here to say that the investigator must avoid conflict of interest and conflict of roles. According to the director, it will be specified in the code of practice. I do agree with your approach, but because the answer to many of my questions is the code of practice, so may I ask the Secretariat to draft a table for us so that we can check whether our concerns can indeed be addressed in the code of practice. Yes, members are quite concerned because some will be addressed in the code of practice or the subsidiary legislation, and the sector is also very concerned. Matters such as the who is to appoint investigators and whether there is a cap to the number. Or will you have first a panel of investigators and then final or to pick the appropriate ones for a particular case? Or will you only appoint investigators specifically when you have a case? So there are different modes of operation. If the director has any rough idea in mind, please let us know now. After the authority is established, every year it has to submit a report to the Secretary for Home Affairs on its work. And the report will also be submitted by the Secretary for Home Affairs for LegCo's consideration. Mr. Wong Leung-Chang-Chi, well, my question is very similar to that of Mr. Wong Kok-Heng's. The appointment of another person is tantamount to giving him powers under Clause 18. These investigators may be involved in various interests, and there is also the problem of privacy. So that the investigators' powers will not be unfettered. For instance, if he discloses or leaks information, then it is also an offense. So can you make it clearer in the bill? restrictions on the conduct of the investigator after appointment. This is my concern. All right, restrictions on the power of the investigator and mechanism to monitor the investigator. This is very close to our heart. Yes, in the committee, there was discussion of this. The investigators should enjoy powers, but we have to ensure that he will conduct himself in a proper manner without any conflict of interest. All these can be found in the Code of Practice, which is an open document. It is not that the authority can drop its own Code of Practice without the public knowing. It should be uploaded to its webpage, and members of the public and LegCo will have access to its full Code of Practice. Mr. Wong Ko-hing, I invited the secretary to do it for us, but I have a new idea. Why don't we ask the administration to do it for us? It should list out things that will be addressed in the Code of Practice. Can the administration devise a table for us as a memorandum or reminder? Because it would be too onerous if we ask our secretariat to check our previous minutes to drop the table. Director, we do intend to draw a summary at a certain time because it is a solemn undertaking made here. We are partners with the Secretariat, so we will work with the Secretariat together to come up with this table so that it will be comprehensive. Thank you.
Mr. Yip Kok-him, I'm still worried because any person being appointed as investigator, shouldn't we clarify that in the Code of Practice? You need professionals, figures of authority, and shouldn't we prescribe the parameters rather than just any person being appointed as an investigator? So what can we do to set our mind at ease, because the drafting as it is right now is rather lax. Other bills, when they mention investigators, there is a basic description of their qualifications and what type of candidates would be preferred. So members are concerned and worried that the scope is very wide. So in the Code of Practice, you might have detailed requirements, but could you elaborate? Yes, we understand Mr. Yip's concerns. We'll examine this. We'll streamline the drafting in response to members' concerns. Mr. Leung Ka-kit. I'd like to probe the department's thinking, why they do not draft it as subsidiary legislation, and why do they have to require the authority to issue guidelines on a regular basis to describe the format of guidelines and how the complaints will be handled. On the surface, this seems to provide flexibility and mobility, but why do we need flexibility and mobility? Because the disciplinary matters, ultimately, after appeal or disciplinary hearing, this will involve the licensee's license being revoked, so the consequences are serious. Well, if it's serious, why don't we spell it out clearly through subsidiary legislation, rather than now having the authority issue guidelines to conduct its affairs? So I'd like to probe the department's thinking. What did they have in mind? Mr. Leung's understanding is correct. Why do we want the authority to work through guidelines in conducting investigations to specify the format of the complaint? It's because that would allow the authority flexibility and mobility in handling complaints. We feel licensing requirements that don't change as often, that we will rely on subsidiary legislation because it's important, but complaints are important, but the way complaints are handled, well, according to different times and experience, they might need to be amended. So we want to allow the authority flexibility in how they handle complaints, but you don't need to worry, because the complaint processes are not drafted behind closed doors. They are transparent. If the public or industry feels they are unfair, unreasonable, they can put forward their objections, and the authority needs to consider the objections. And if any person is dissatisfied with the investigation, we have an independent appeal mechanism. It's totally independent from the authority. It's a separate system. The appeal authority can handle any outcomes that are deemed unreasonable, unfair. I want to ensure that this complaint mechanism will not be challenged or as being against the natural justice. The guidelines, since it's not subsidiary legislation, then when the guidelines on processes are published and announced, then does LegCo have a role? Or should the authority have a role? How do the public participate in input? How do we handle the gray areas? It's not clear. Because if you say if we have a subsidiary legislation, I can understand that, but does that mean whenever the guidelines are amended, it has to be discussed in LegCo? I want to clarify that. It's somewhat important. Well, since it's an industry guideline, we have to rely on actual experience to make amendments. So we conjecture that these guidelines need to be updated regularly. And since it's an industry guideline, it should be handled by the authority. But as I reiterated, this is open information. It has to be on the website and announced through different media. The public, especially the industry, should have ready access to these guidelines at any time. If there is any dissatisfaction, they can make appeals to the authority. We will take note of the development, and when necessary, we will intervene with the authority, so you should not worry. Other monitoring authorities, regulatory authorities, also update their guidelines, including investigations. So could you elaborate? There are other regulatory authorities. So what other regulatory authorities did you draw reference from? This practice is similar to the competition ordinance. The competition authority can make regulations and guidelines. So we're not the only one. Well, you mentioned the competition authority. I have some recollection, but their guidelines have to pass through LegCo. For example, this Property Management Services Bill, when it comes through LegCo, we didn't have the guidelines. So I'd like to understand your thinking. We don't have the guidelines now, or when we resume second reading, will there be a guideline, Mr. Chan? The guidelines will be drafted by the authority. So before an authority is established, we can't have guidelines. So the authority has to be established, and then they will draft the guidelines. So could you remind me the guidelines of the competition authority under the competition ordinance? How was it handled when it went through LegCo? I don't have this information on hand. I need to come back later. Well, I recall that the competition authority, we did have an interception point. It wasn't just announced and implemented. We had some, I recall having some discussion during the legislation process. Well, since I mentioned it, the department should take note. During the drafting of the guidelines, if there was no detailed consideration, there might be some regulations that are against international justice, then it would come back to haunt you if you seek appeal and the appeal is denied. That's not your intended outcome either. I am done with Clause 20. We are all concerned about appointment of investigators. It's not drafted clearly because after the investigation, there might or might not be a disciplinary hearing. It depends on the authority. An investigation is separate. Whether a disciplinary hearing is arranged, it would be decided by the authority. But the investigation, are they under instructions of authority? And then the authority conducts an investigation through these investigators, and then they will decide whether to convene a disciplinary hearing. Is that the line of thinking? Yes, basically that's it. When the authority receives a complaint, the authority will delegate to the disciplinary hearing committee, and the investigators will collect information. After the investigation, the report will be submitted to the disciplinary committee, and they will decide whether to convene a hearing. That was my understanding. Well, then we might not need to be too worried who these investigators are. The authority will be responsible. The disciplinary committee of the authority will be ultimately responsible. These investigators are authorized by the authority. So if the disciplinary committee and authority bear responsibility, because they will appoint the investigators according to Clause 23. Mr. Leung's understanding is correct. The investigators answer to the authority and disciplinary committee. Mr. Wu Jiwai. Regarding the subsidiary legislation that has to be endorsed, it seems that we will apply negative vetting as described by Mr. Leung. The public and LegCo are concerned because we have to rely on the department and government for a lot of details, but these are not comparable to the framework as described by the subsidiary legislation. We will only be given a memorandum or there's no opportunity for detailed consultation. So there might be two scenarios. The director, you should hand us the subsidiary legislation as soon as possible rather than just a framework, so that we can engage in discussion and decide how to proceed. The second scenario is that in legislating the subsidiary legislation, you want to, in order to enhance efficiency, we should have negative vetting since we are working with a time constraint. So negative vetting would give us sufficient time, would give the public sufficient time to deal with changes and to have discussions, to deal with Mr. Leung's concerns on whether there would be breaches against natural justice. So I'd like to hear from the department.
Yes, Director. As mentioned in many previous meetings, the administration appreciated that members were concerned about the subsidiary legislation. When the subsidiary legislation is ready for presentation, we will submit it to the relevant panel for consideration. And in fact, the guidelines are not subsidiary legislation. They are just procedural guidelines, and they have to be updated from time to time. And in other pieces of legislation, such guidelines are formulated not in the form of subsidiary legislation, but as I said, it is public information, and the public can have access to it on the relevant website. Mr. Wu, the authority will be dealing with the guidelines, and I know this is a usual practice, but this is also about the composition of the authority. So, Mr. Chen, you are going to give us a preview as soon as possible? I'd like to know whether it is just a framework or the actual draft. Because we were told that if at a certain stage we wanted a particular piece of information, the administration would give us a rough idea, not the legal document itself. And if my understanding is correct, the bylaws will be passed by positive vetting. That includes the composition and details of the authority. Perhaps this part should be taken out for a positive vetting of the Council. Director, Mr. Wu talked about some very important provisions, including the composition of the authority. It can be found in the bill under Schedule 3, so members can be assured when the bill is passed, the provision on composition of the authority will also be passed. For the guidelines, we will make them detailed, but they may not really be like legal documents. Because some licensing requirements have to be drafted by the authority. So it should be for the bill to be passed first and then the authority to be set up, and the authority will set out licensing conditions. But we can submit some the framework and also points already agreed to by members in the Bills Committee. Was submitted to this Bills Committee for consideration as soon as possible. You have to ensure that we'll have enough time to study those proposals. Mr. Wu, can the administration tell us once again clearly bylaws under the bill will be passed by positive vetting? I know that in for some of the bills they may go for negative vetting. So can you say for sure or tell us specifically why for regulations under this bill you're going to use negative vetting? What considerations do you have? Yes, this is a deliberate decision because we've conducted widely a number of times on the licensing regime, and we have also considered views received. And the outcome of public consultation is the public would like the bill to be passed as soon as possible so that the mechanism can be set up ASAP. To address the community's concern, we believe it is necessary to license companies and petitioners as soon as possible. And therefore, the subsidiary legislation will be passed by negative vetting so that the licensing regime can be launched ASAP so that we can upgrade the quality of build property management services to benefit the public. We do understand members' concern about subsidiary registration, so we have undertaken to provide the detailed proposals to this BC for scrutiny ASAP. Thank you. Any other questions? If not, we'll continue. Clause 21, bracket 1. Thank you. Clause 21 is a power to obtain information and documents by investigators. Under subsection 1, if an investigator has reasonable cause to suspect that a person has or may have possession or control of information or documents relevant to the investigation or may otherwise be able to assist the investigator in relation to the investigation, he may ask for such information to be provided. Subsection 2, the investigator may, by notice in writing given to the person, require the person to provide him with any information relating to a matter he reasonably believes to be relevant to the investigator, and also to provide him with any document relevant to a matter he reasonably believes to be relevant to the investigation, and he can require the person to attend an interview with him and to respond to any written question. Subsection 3. A notice under subsection 2 must indicate the subject matter and purpose of the investigation, and the investigator must specify in the notice the time and place at which the document is to be provided and the manner and form in which the information is to be provided. Subsection 5. The investigator may ask for the information to be submitted in a visible and legible form or by electronic form. And if the information is stored electronically, the authority has the power to require the provision of instructions on the operation of the equipment containing the information. And the power under this section to require a person to provide document includes to make copies of it or take extracts from it, and to give an explanation or further particulars about the document. And if the document is not provided, the investigator has the power to require the person to state where the document is. Mr. Wong Ko Heng, a few questions for the administration. First, this is about the investigator's power to obtain information. I'd like to know whether that power will be exercised in confidence or in an open manner. There is no specification on this point. When ICAC conducts an investigation, it has to be done in confidence to be fair to the complainee. Because for the person under investigation, he should be presumed to be innocent. Otherwise, he will have to go through a trial by public opinion and the media, and it's not fair. There is no specific provision here on confidentiality, and to require the process to obtain information to be done in confidence. So can you please comment on this? Secondly, subsection 4A, the time and place at which the information is to be provided. This will be specified by the investigator, but it must be reasonable as well. Will you ensure that the requirement is reasonable? Because the time and place may not be reasonable. So shouldn't there be some restrictions here? Can our legal advisor help? Because I am a layman. So legal advisor from our secretariat, please assist me whether we should have a clearer provision here. And what will happen to the person who willfully or deliberately makes life difficult for the investigator by not complying? So what will be the penalty? There is no mention in this paper, in this provision as well. Mr. Kwok, of course the investigator will have to obtain information from the complainant and to let him know what is the relevant matter. There will be guidelines for the investigator to follow to ensure that the matter will not be disclosed to an outsider. And the provision of a document should be done at a reasonable time and place. I agree with Mr. Wong. The investigator should give due consideration with regard to the circumstances of the case, and the power to obtain information will be by means of a notice in writing. If anyone who refuses to comply with the notice, that under Clause 22 is an offense. Under Clause 22, a person is required to produce the information required. What about confidentiality? There is no explicit provision. Yes, you agree with my view, but there is no explicit provision here to ensure that. You agree with me that at the time and place for provision of information should be reasonable. You agree with me, but there is nothing in the bill to require that. Any assistance from the legal advisor? I'm a layman here. Director, if I may have a go. The conduct of an investigator. Yes, as said by Mr. Wong, it is important that he can maintain confidentiality. There will be a code of conduct by the authority to regulate the conduct of its employees. For instance, an investigator cannot disclose details of his work, including investigations to an outsider without good reason. Mr. Wong asked about the time and place at which the information is to be provided. Yes, it will be clearly set out in the code of practice. For instance, the time and place, the place must be an office of the authority, and the time cannot be unreasonable. For instance, information should not be asked to be produced on the same day. This is unreasonable. All these will be set out in the code of practice, and as I said, the authority is subject to public scrutiny, and there cannot be any unreasonable request.
Regarding reasonable time, some legislation will spell it out. If we're talking about submitting documents, we don't need to spell out the reasonable time. Sometimes we have a search warrants in premises, so we won't have a search warrant for a home premise in the middle of the night. So all exercising of authorities have to be done in a reasonable time frame. Otherwise, they would be subject to judicial review. Well, they don't say that the investigation has to be confidential. Well, it's not spelled out, and if you were to ask, I would agree. When exercising authorities in an investigation, the authority and the person conducting the investigation, they have to be identified. Well, the legal advisor agrees, the department agrees. Well, the director said that in the code of practice or guideline it would be spelled out. So in all these guidelines, we don't have it in the Blue Bill. How do we regulate that? So even all civil servants, all regulatory authority employees need to comply with the law. But I want to specifically highlight the investigators in exercising their investigatory duties. They have to act in confidence. They need to maintain confidentiality. And if we don't spell it here, it might be a loophole. this loophole might be abused to break the law, or it might be unfair or unreasonable to the people involved. It's not fair to all the parties involved. I agree with Mr. Wong. The investigators, when they have very wide-ranging powers under the common law, information that you receive through investigation that has to remain confidential. So sometimes the information retrieved might be controversial. So I agree that we should spell out that would ensure the greatest safeguard. Well, I'd like the director to acknowledge and agree with the legal advisor's views. We mentioned that the authority, when they draft the guidelines, they would have to spell out all members of the authority, not just the investigators, need to maintain confidentiality. Just now, Mr. Wong suggested that we draft a table of follow-up actions. We will include this confidentiality requirement. The authority, when it's established, the authority will need to draft specific regulations to ensure confidentiality amongst members and investigators. Okay, thank you for your pledge. I have another question. The investigators, they need to gather a lot of information. The information that they receive, regardless of how the case develops, this information, is there any restraint or is there any requirement that the information be destroyed, or who has access to the information, and how long can this information be kept? Is there any regulation? How do you handle that? These specific, well, it's very important. I agree it's important. This will have to be handled in the guidelines in the future. How they will handle documents destroyed and kept. All these will have to be spelled out in the guidelines. I want to ask the legal advisor, can they just can they get away with such a vague promise? It's not mentioned how long can documents be kept, will they be destroyed, and so on. Legal advisor, anything you can add? I don't have a strong view. These can be handled by internal guidelines. Chairman, let me add that other statutory bodies have similar arrangements. This detailed work is handled through internal guidelines. I mentioned just now, the authority faces different constraints. They need to report to our bureau. Our bureau reports to the LegCo every year. The authority is also monitored by the Ombudsman and ICAC. They have to live up to the public's expectations. Well, this investigator is similar to ICAC investigators' powers. It seems that way. Do they have such large powers? It's like ICAC investigators. The ICAC will treat you to a cup of coffee during investigation. The authority has investigation powers, but the powers are proportionate to our requirements of them. They won't have they are not given too much power. The current Blue Bill refers to the powers of the investigators. Well, all the salaried staff are accountable. I'm not too worried. The investigator, it's just a job to the investigator. And during the investigation, they, as the director said, they are constrained by other laws as well. So, after investigation, how is the information stored and destroyed? That perhaps is a matter for the authority rather than the investigator. The investigator is just a frontline worker. So I don't have strong views on this, but rather after the investigation is concluded, how will the information be handled? Should we have a policy of destroying the information after a certain time frame? I think that we need a response on that rather. The guidelines will definitely list that in detail. Regarding how long we can keep the information, it will depend on actual experience. The investigators will maintain the highest confidentiality. We will have to keep records until the appeal is ended, and we'll have to keep it for a period, reasonable period after the appeal. So the investigations will revolve around the complaints. Legal advisor? Regarding Clause 21, I do have some drafting questions. Well, other legislations refer to documents. We're not talking about paper documents. It could be a digital, electronic document. So in the interpretation, should we refer to documents as being stored digitally and electronically, not just limited to paper documents? We agree with the legal advisor, and we understand that there are different formats of document, so we will consider whether we will need further amendments. Legal advisor? Another drafting question is 5B, information stored electronically. In 5B, if the information is stored electronically, do we require the complainant providing a written document to the authority as well? We had responded previously that the legal advisor's view would be included through an amendment of the legislation. The last point on drafting relates to 6A2. It requires a person or any other person who is or was an employee or partner of that person to give an explanation. It just refers to employee or partner. But if it is a company, should that include senior management and directors as well? Could you take us through the specific legislation? It's 6A2. on page 2778 on the top. We agree that it should include senior management and directors. We will consider an amendment. If we have no further questions, please continue. Clause 22. Clause 22 relates to offenses relating to investigation. According to Clause 21, if a person commits an offense if the person without reasonable excuse fails to comply with the requirement of a notice given to the person under Section 21. And a person commits an offense if the person knows the person in purported compliance with the requirement of a notice given to the person under Section 21(2) provides any information or document, gives an answer, response, explanation, or particular, or makes any statement that is false or misleading in a material particular. And a person who commits an offense under subsection 1 or 2 is liable on conviction of an indictment to a fine of 200,000, to imprisonment for a year, or on summary conviction to a fine at level 6 and to imprisonment for 6 months. Any questions relating to Clause 22? Mr. Wong Kok Heng. 22 is about offenses. I want to backtrack to the previous clause. In 4A, I mentioned that we should have reasonable time and place in which the information or document is to be provided. The Bureau and Department agreed and said that it would be spelt out in the guidelines. But the legislation is not amended. If you look at, if you compare that to Clause 22, this is serious. This says that if you commit an offense, if certain acts are committed, but in the previous part, they don't refer to a time and place. So I identify a serious consequence here.
But I believe there will be reasonable defense. Yes, Chairman, your understanding is correct. As said by the legal advisor, the exercise of public authority must be reasonable under the common law. So if it is a reasonable excuse, then it can be a defense in court. The court can decide whether there is reasonable excuse for not complying with the requirement. So, the investigator is not required to make a reasonable request with regard to time and place. Why can't you? I don't know how to say it. Why can't you say the information should be provided at a reasonable time and place as requested by the investigator? Well, as I said, the relevant requirements will be clearly set out in the Code of Practice, and we have to have regard to different circumstances of the case, and we must give flexibility for the investigator to make a decision. And of course, if the person deems a certain request unreasonable, he can take up with the investigator. If the case subsequently goes to court, then the person can make a defense. So, Mr. Wong, you're saying that you should make it fair for both sides? You're correct, Chairman. And then the Administration said just now that it can be set out in the code of practice, but it is entirely different from having it in the bill. Chairman, if I may try to supplement. Requiring the time and place at which the information is to be provided. Now, it is not as general as to allow the investigator to specify. Rather, the authority will, through its code of practice, require the investigator to specify the time and place. So it is, in fact, the authority that specifies the time and place. The code of practice will set out what is meant by reasonable time and place, and again, it is public information. Chairman, can you change subsection 4 a little bit to reflect what you said just now? Because subsection 4 says the investigator may also specify in the notice the time and place, blah, blah, blah. If it is in fact the authority that specifies the time and place, why don't you reflect this in the bill? Can that be done? Mr. Chen? Different members have expressed concern about this requirement for the information to be specified at the particular time and place. We'll see how this bill can be improved. I welcome the director's position. However, failure to comply with the request under subsection 4 is an offense, and therefore you must be fair to both parties. So you have to make it clearer so that people will not be inadvertently caught so easily. Okay. Anything more on clause 22? If not, clause 23. Mr. Kwok, thank you. Clause 23, disciplinary hearing. Once an investigation is completed under clause 18, and if the authority is satisfied that there is evidence that tends to establish the matter mentioned in subsection 18(1)(a), Roman 1 or 2, in respect of a licensee, the authority may decide that a hearing in the matter should be conducted, and the matter is to be heard by the authority or, on the authority's direction, the disciplinary committee. And the authority must, as soon as practicable, notify the licensee in writing of its decision. Okay. Any question on clause 23? All right, if we have no further points, Mr. Kwok, please. 24. Hearing before authority. Subsection 1 allows the authority to take evidence on oath, to summon a person to attend the hearing as a witness, to give evidence, and provide any information or document in the person's possession under the person's control that may be relevant to the hearing, or to examine witnesses, to award to a witness the expenses that, in the authority's opinion, the witness has reasonably incurred because of his attendance. Subsection 2. At the hearing, the case against the licensee must be presented by A, the complainant or his legal representative, B, the chief executive officer or any other employee of the authority appointed by it, or a solicitor or counsel engaged by the authority. And subject to subsection 4, the hearing is to be held in public. Under subsection 4, after consulting the licensee and the complainant, the authority may by order direct that the hearing or any part of it be held in public. And 5, if the authority makes an order under subsection 4, it may also by order prohibit or restrict the publication or disclosure by any or all of the persons present at the hearing of any evidence given at the hearing or any matter contained in information produced or received in evidence at the hearing. 6, for the purpose of subsection 4, the authority must take into account the views of private interests of the licensee and of the complainants, including any claims as to privilege. 7, if a person fails to comply with an order made under subsection 5, then the authority for a person who is a licensee may make any of the orders described in subsection 25(1) against a person, or for a person who is not a licensee may give the person a public reprimand. 8, a party to the hearing may be present at the hearing personally or may participate in person or through a legal representative or with the consent of the authority through any other person. And a company is to be regarded as participating in person if it participates through any of its directors. And 10, subject to other provisions of this section, the authority may conduct the hearing in any manner it considers appropriate. All right. Clause 21, subsection 1. Do we have any comments? Legal advisor. 24(1). 36(1). Now this is very similar to Section 31 of the Appeals Tribunal, that is Section 36(1)(d). 36(1)(d). And that is to receive and consider the material, whether by way or oral evidence, written statements, documents, or other things, even if the material would not be admissible in civil or criminal proceedings. Will you consider giving the authority a similar power? Yes, so we agree to the legal advisor's view and will make appropriate amendment to enable the authority to receive or consider materials that will not be admissible in civil or criminal proceedings. Any more comments on subsection 1? If not, clause 24, subsection 2. Any comments or questions? May I ask, in relation to information sought by the investigator, we talked about confidentiality. However, a hearing may be held in public. Then the information is it that the document or information doesn't have to be kept confidential anymore at a hearing, unless the hearing is held in camera, or else all information is already open to the public. Is that correct? And we're trying to strike a balance. On the one hand, we want to ensure that the hearing is comprehensive and is comprehensive, and during investigation, for the sake of privacy, things have to be kept confidential. And if the authority decides to convene a public hearing, then I'm afraid the information will have to be made public, unless we are talking about very sensitive information and with the consent of both parties. a closed door hearing may be held and the information can be kept confidential. Okay. Mr. Kwok, please go on. Para 20, or rather, Clause 25. Clause 25. If at the conclusion of a hearing, the authority is satisfied that a licensee... Oh, I beg your pardon. But we haven't gone through subsections of 3, 4, 5. Oh, yes. We've still got other provisions in Clause 24 regarding bracket 4, consulting the licensee and the complainant. What are the criteria for hearing to be held in private? As I said, if there is sensitive or commercially sensitive information or things involving privacy, personal privacy, we will allow a private hearing to be held. But for the details, I'm afraid we'll have to wait until the authority and the disciplinary committee under it to decide. Because we cannot be too general. It depends on the merits of the case. You talked about after consulting the licensee and the complainant, if any. That means you need to have the consent of both parties before hearing can be held in private. Well, this is about consultation. The final decision rests with the authority. All right, so it is for the authority to make the final decision.
冇其他。
Bracket 5, 6, 7, 8. Then we can move on to Clause 25 then. Clause 25 says that if at the conclusion of a hearing under Section 23, the authority is satisfied that the matter mentioned is in Section 18 is established in respect of a license, the authority may make any of the following orders, including a verbal warning, written reprimand, and a fine can be imposed, not exceeding the amount specified in Schedule 2. It's 300,000, and a condition on the license can be imposed. Condition of the license can be varied, and an order suspending the license for a specified period or until a specified event occurs. The license can also be revoked. If the authority makes an order under subsection 1 against the license, it may also order the licensee to pay the costs and expenses incurred in relation to the hearing, whether by the authority or any person attending the hearing as a witness. If the authority makes an order under subsection 1 or 2 against a licensee, it must, by notice in writing given to the licensee within 21 days, beginning on the date on which the order is made, also have to notify the licensee of the order, and an order made under subsections 1 or 2 takes effect on the date of the order, or if a later date is specified in that order, that later date. So subsection 4 applies even if the licensee has lodged a notice of appeal under section 33, or the time for lodging the notice of appeal has not expired, or a notice of the order has not been published in the Gazette. Subject to subsection 7, the authority may, of its own volition or on application by order, revoke, vary, or suspend an order made under subsection 1 or 2. Before making an order under subsection 6, the authority must satisfy itself, so far as that it can reasonably do so, that the order would not unfairly prejudice any person. And the fine, costs, and expenses mentioned in subsections 1b and 2 are recoverable as a civil debt. 25(1). Any questions? I'd like to ask, during the hearing, if the orders under 25(1)(a) to F is the case is only the case concerned, or is the license holder, the licensee, previous disciplinary breaches, are they also considered? Or will the disciplinary hearing only deal with the case on hand? During the discussions in the consultation committee, each case is considered independently to decide whether the complaint is substantiated. But the penalty will consider other factors, such as were there any previous complaints? If they had previous offenses, the penalty would be heavier. The purpose is to maintain standards in the industry. I also want to follow up regarding these orders. We have verbal warnings, written reprimands. Will these the case is looked at independently. The penalties against the licensee, the authority will have to consider past offenses. So, let's say they received a verbal warning many years ago. Will that be considered? The authority will have to decide based on the guidelines. My understanding is that the consultation committee would have to consider, would have to balance the different offenses. So if it was just a verbal warning, it wasn't a serious offense, so it would not be considered in future hearings. So in 25(1)(b), a fine is mentioned. So regardless of whether you're holding a Tier 1 or Tier 2 license, is the penalty the same? So if it's a company held or a personally held license, is there any difference? We're talking about a maximum penalty. The actual penalty will depend on the case. It also depends on the seriousness of the case. So the authority will determine what penalty can reflect the seriousness of the offense. Thank you, Chairman. I'd like to follow up in E, suspension of license. Is there any maximum length for a temporary suspension? Because F revokes the license. We have to wait for the authority to decide. The authority will balance different considerations. Any questions on 25(1)? We then move on to 25(2). Any questions? We continue to 25(3). (25(4), legal advisor. In bracket 4, will that be affected by subsection 6? Mr. Kwok. Thank you, Chairman. It would not affect the date of effect. So do we need to spell out subsection 6 should not affect subsection 4's effective date? We'll consider whether we need an amendment to clarify that. Clause 25, bracket 5. Do we need to refer to section 33? The understanding here is that when they enter section 33, the date mentioned in subsection 4 continues to take effect. So even if you appeal, according to 25(1) and 2, the decision is still carried out. Does that give rise to any problems in reality? Mr. Yip's understanding is correct. So even if the person lodges an appeal, the order continues to take effect. So this should not have any significant impact on actual operations. So in your guidelines, should you set a time frame for appeal? So if an appeal lasts for 6 months to a year, it might affect the operations of the company. According to section 33, the appellant needs to submit notice of appeal within 20 days. After lodging an appeal notice, an appeal tribunal will handle the appeal, and the appeal committee chairman will determine an appeal date, and the appeal needs to commence as soon as practicable according to actual conditions. Thank you, Chairman. So we don't have a time frame. You're saying that it has to be conducted under practicable conditions, so it might take up to a year. Well, in our experience from prior appeals boards, they need to prepare documents and invite witnesses. So the actual date will depend on the preparation work. But as I said just now, 35A, we want the date to be as soon as practicable to prevent any stalling. Well, you require them to submit information within 21 days, but you don't specify when the appeal can be heard. So you're saying that's flexible, but wouldn't that be too flexible? Of course, they have reasons if they want to appeal, but whether the appeal is granted or not, it depends on the appeal committee. But then the appeal committee hasn't set a time frame. So the appellant has 21 days for submitting an appeal. That is clear. But appeal decision is very vague. I don't think that's reasonable. Well, when can the appeal committee convene? So we cannot give you a specific time frame. I think it's the same for other appeal mechanisms. My understanding is that it's the same for the courts. After a ruling, you are given a time frame for appeal. But when can the appeal convene? It depends on actual circumstances. So I feel that the authority would have performance pledges in its guidelines. Usually within a certain number of days, they can arrange an appeal hearing. They can set some indications. Well, I recall that previously we did have a time frame. It wasn't that vague. If you draft it in this manner in the principal legislation, I'm very worried. The appellant would feel that it's unfair. You have to be seen to be fair. So we need to consider this. Chairman, these are performance pledge issues, as I said in the beginning. For example, in the Lands Tribunal, how long it takes depends on the length of the queue. Their performance pledge is 90 days, but in 2014, on average, they could handle it in 30 days. So we will have a performance pledge, but if you want to set a specific date, it might be difficult. In the future, we'll have to rely on the authorities' guidelines to set a date. This is public information. You can check on the performance pledge, and you can whether it's reasonable. The public can decide. Well, time is up, but I'm aware Ms. Ley Wai King has a question, so we'll extend by 15 minutes, or Ms. Starry Lee.
I apologize for being late. If there are questions already asked, I apologize. I just want to make clear certain things. Will the authority issue guidelines in the future so that all licensees will be made aware of the requirements, because it's quite complicated? After all, we'll talk about a license for property management, and the relationship between the OC and property management agencies is involved. Sometimes the property management agency is doing it at the direction of the OC. So we make a distinction. I think this issue was discussed when we discussed the policies. In the code of practice, we will advise petitioners and property management agencies to remind OCs that they have to act in accordance with the law. If the OC fails to comply with the law, then the PMA or the petitioner is duty bound to continue to advise the OC. But if it is to no avail, then this can be used as a defense when a case appears before the authority. Any more questions? No more. All right. Any more questions on clause 25 of the bill? If not, we will call it a day, and then for concerns raised by members at the meeting, and also follow-up responses, can the administration give us reply in writing afterwards. All right, the meeting ends here, and the date of next meeting is the 21st of April, Tuesday, at 2:30 at room 2A. Thank you very much for your attendance. Meeting adjourned.